Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Mansfield. He's joining me at the table.
And we are here for a probable cause conference. Is there any resolution?
There is not, Your Honor. There is a point to be made with regard to his situation on the bond that I would like to flesh out more before the court here today, with everyone's consent.
All right. So since there is no resolution, we're set for a prelim next week, then is there any discovery issues or any issues that might crop up between now and then?
That's a good question, Your Honor. I'm not sure that I have. Do you records indicate that we have the cap?
I think these.
Okay, which I've said, so I have not seen the CAC. I'm sorry, Your Honor, I lost my train of thought. There was something else that I had in mind. Perhaps it'll come to me in the ensuing discussion.
Mr. Carnes, have you received back the signed protective order from the defense requesting the CAC interview?
I don't believe we've received that back yet, Your Honor, but this was all.
It was on my desk this morning, Your Honor. I think
Okay.
I may even have it with me, so that might be a minor point that wouldn't be any need to postpone the prelim simply because of that.
All right. Okay, then we will keep the prelim set for next week.
I think that's appropriate.
And you said you wanted to address bond, Mr. Harrison?
Well, there is one other potential issue, and let me flesh it out. I remember what it is now because it does relate to his bond. But let me start here. You've currently got him $100,000 bond. And one of the factors I believe that you considered was his status as a parolee at the time of his arrest in this matter. We've since come to learn, as has the court, that he is not a parolee in the state of Minnesota anymore. Minnesota or Wisconsin? Michigan. Wisconsin. They're the same place to me. I apologize. He is no longer a parolee. And therefore, to the extent that that entered into the bond decision or the amount of the bond that was placed in this case, I would ask that the court re-examine it in that light. He is not a flight risk. He's full-time employed. He lives here in town. He has for a significant period of time. He does live with old adult relatives. He's lived there for a long time, all of that kind of stuff. I think it's interesting to note as well that the investigation into this matter was lengthy, almost 2 years long. And despite the fact that he knew he was under the watchful eye of the law enforcement, he did not alter his routine and continued to go to work and do all of those things as well. I guess I would understand if the court wanted a cash bond of some variety. He just lacks the resources to post even a bail bond in the amount currently imposed.
When was he removed from parole, and do you have anything showing that? Lien shows that he's on parole until May 5th of 26. Mr. Carnes?
I had an email from Agent Van Ackmel last week confirming that he had been released by the state of Wisconsin. I did not know that. I don't know the exact dates.
Yeah, and apparently that information did not get to, let me get into that right away too. I want to tee this issue up too, was to the extent that they have evidence secured from Mr. Mansfield's telephone, that was not secured by a search warrant or anything. That was secured because Mr. Van Ackmel took it from him in his capacity as a parole officer at that juncture. I'm teeing that up because I don't know where the evidence is coming from in some of these instances. Go ahead.
Thank you, Your Honor. Obviously, that's a separate issue. I think the good faith exception gets us past that, but even if all that evidence got thrown out, the likelihood of conviction is still high. We have the victim's cell phone in this matter. Additionally, I would state As far as the defendant being on notice of this investigation, the only thing I see was an interview on August 18th of this year. So yes, the allegations are almost a year old. But the investigation is largely more recent. I think bond is set appropriately where it's at. It does seem defendant knew the victim's age in this, as she was close friends with I think a family member of his, and it is yeah, there's text messages corroborating that largely corroborates the victim's story. I think the likelihood of conviction is high. I'd ask the court to leave bond where it's currently set. Thank you.
Give me just a moment.
Your Honor, it was my understanding that Mr. Van Atmel informed the court of the same thing, so I apologize. That's not what happened.
And he may have, I just,
Okay.
if he did, I didn't notate it in my arraignment notes, and I just see lien still shows it as active, so. I'm just reviewing the probable cause affidavit, so give me a moment. All right, when reviewing the bond conditions, the court looks to Michigan Court Rule 6.106. And one of the things we look at is a prior criminal record. In 2021, there was a trespass and a UDAA, 16 a UDAA, and in 20 a burglary. Record of appearance, failed to appear, or flight to avoid prosecution. I do not have anything in that regard. And the court is now aware that the defendant is off of parole despite what lien indicates. History of substance abuse or addiction, there's nothing to that. Mental condition, character, reputation for dangerous, nothing has been presented to the court of that. Seriousness of the offense charged. This is a very serious offense. There's a CSC charge of a 15-year, a distributing sexually explicit visual material, 2 counts of that, which are 2-year felonies. Probability of conviction, while the court does not make that finding today, I have read the probable cause affidavit, which at least on paper looks like there would be some sort of conviction. Likely sentence, I have not scored the defendant, neither, I'm assuming neither had the attorneys, otherwise that would have been presented to me today. Employment and financial status history, it does sound like he is employed, or was at least at the time of his arrest. Responsible members of the community who would vouch for the defendant, nothing's been presented today. In ties to the community, family ties, relationships, links of residence. I do see he has a Cadillac address. And any other facts of risk of non-appearance and danger to the community. The court did set bond conditions back on August 21st at finding that the defendant posed as a threat at $100,000 cash surety, along with a no contact with the minor victim in this case, no contact with anyone under the age of 16, unsupervised contact, and GPS tether house arrest for community corrections, in addition to the other standard bond conditions. Although I will note that at the time of the arraignment, he'd indicated he was unemployed. Mr. Harrison presents the court that he stayed in the area after knowing of the investigation, but Mr. Carnes indicates that he would have learned of the investigation only 3 days before. Without knowing more and with the allegations as shown, the court will keep bond where it's currently set. Anything else, counsel?
No, Your Honor, thank you.
Not this time around.
Right, we're adjourned. And that brings us to the people of the state of Michigan versus Stephen Crane, case number 253791 FY. Appearances, counsel?
Hey, Carnes, on behalf of the people.
I'm Jeff Harrison, here on behalf of Mr. Crane, who's joined me at the table.
And we are here for a probable cause conference. Is there any resolution in this matter?
There is, Your Honor, however, the proposed resolution would constitute a high court misdemeanor, such that I would have Mr. Crane execute a bind over today. I just haven't presented it to him yet.
So before you sign that, I guess I have a question for you, because the court rules say if there's an agreement reached at the district court level, the district court shall take the plea.
We
So-
certainly can do that if the court is willing.
Well, I also know that Mr. Carnes has some paperwork he would have to put together for that. So I'm wondering if we just want to set this for tomorrow and take a plea tomorrow.
Yeah, that sounds great, actually.
Mr. Carnes, will that work for your office?
That
All right,
Fantastic.
and that will work for us. So let's get this on the morning docket then, and we will take a plea in the morning.
So we'll see you tomorrow.
Anything else, counsel?
No, Your Honor.
No, Your Honor.
Okay, we are adjourned. That completes the morning docket. We're adjourned for the morning. All right, any allocution, Mr. King?
Thank you, Your Honor. Your Honor, I think as the court can see, both from the alcohol assessment and counseling, Ms. Bodette's been very upfront about this. This served as a great wake-up call, especially because of the higher alcohol level and her not realizing how much it had affected her at that point. Saying that there was a lot going on in her life at that time, as the court can see, not only with her divorce, but also having just lost her job that she'll have due to downsizing. She is an advocate for the counseling that she's in. I think you can see from the letters, she's committed to it. She was committed to it before this incident and has continued that. We would ask the court to consider the fact she is going to be going to Al-Anon, and her counselor believes Al-Anon because of her background is more beneficial than AA. But you will not see Ms. Bodette in front of you again for all.
Thank you. Mr. Carnes?
Thank you, Your Honor. I noted the recommendation in the evaluation was to attend 6 to 9 months of individual therapy sessions, and it looks like she's already started that. I also noticed the diagnosis. I think both of those do warrant a period of supervision, especially considering the blood alcohol level was a 0.183 in this case. I would ask the court to sentence the defendant to a period of supervision.
You said the blood alcohol content was a 0.183?
Yes, Your Honor.
Right. Ms. Bodette, you have the right to address the court before sentencing. Is there anything you'd like me to know?
Your Honor, you'll never see me here again for this. I understand how alcohol has affected my blood alcohol and driving, and I will never do that.
All right, thank you. Ms. Bodette, I'm going to ask you what I usually ask everybody in these situations. What have you learned from this?
That alcohol definitely affects my blood alcohol more than I thought it did. In my impaired, I didn't realize how much it does impair your judgment. And then I need to go to Al-Anon for everything I've gone through in my life, and counseling has helped me.
Good. And I saw reading the substance use assessment that there's some stuff going on there, and I appreciate that, and I think it gives helps one develop more in their understanding with alcohol when they know what's going on in the background and how that affects it. At least my records show you don't have a criminal history, that this is your first offense. I have to say that the assessment made me chuckle, and I had to go back and look at your birth date, because when I saw what you first started consuming alcohol was with the Bartles and James wine coolers, it popped in my head. We thank you for your support from the commercial. So I realize that the assessment says that you have a severe issue, but I also realize that you must be able to control that somewhat. Otherwise, we would have seen you long before now. And while I do realize there's a presumption of no supervision in a case like this, I think it's going to be beneficial to supervise you somewhat. The recommendation is that you attend some counseling, what you started, that you attend some services. And while I have no doubt you're going to do that, I want to make sure we give you the added support and help to make sure that you are doing that. Now, how long have you been working with your counseling?
On and off for the last, well, it's been almost probably 2 years solid, but going into the divorce, I started counseling until the roads were getting bad. I don't like to drive on the country roads.
Okay.
So I've been with her for almost 2 years now, solid.
And how long had you been employed at your employer before the downsizing?
2.5 years.
Okay. All right. Is there anything else you'd like me to do?
No, yeah.
All right. As I said, I am going to put you on a period of probation. I'm going to order 12 months probation, but this charge allows you to be released early if you've done everything that we need you to do. And I'm taking that into account because the recommendation is for basically 6 months of services. The halfway mark puts you at the 6-month mark. So as long as you've done everything we need you to do, you could be released at that 6-month mark. If something happens that your probation officer doesn't think you should be released, but you think you should, you can petition the court on your own, and we'll have a hearing and I'll make a decision on that. But during the time you're on probation, you are not to violate any law. You're to report as ordered, not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. As I said, you are eligible for early release. I'm going to order that you attend the alcohol highway safety education class and the victim impact panel. No alcohol. Not that this is indicated that there is an issue with it, but I'm also going to order no illegal drugs or no recreational marijuana. I don't want you trading one substance for another.
No, sir.
You'll be subject to testing pursuant to the terms of your probation officer. You must follow the recommendations contained in the substance use assessment. No bars where the primary source of revenue is the sale of alcohol. Restaurants that serve it are fine, just no bars. No alcohol or illegal drugs where you reside. I'm not going to order you into a recovery program, but as Mr. King said, you have plans to do something along those lines, so I highly encourage you to stick with that. Any counseling that your probation officer determines that you need to attend, including drugs and alcohol counseling, and any additional programming that she feels is appropriate. You do have 3 days jail credit on this, so I'm imposing a 3-day jail sentence with the 3 days credit, so you've sat your time served. There is a $75 crime victims' rights fee, $50 state minimum fee, $300 fine, $150 court costs. Mr. King, you retain, correct?
That is correct, Your Honor.
Mr. Carnes, any restitution requests?
Yes, Your Honor. $200 to the Michigan State Police and $100 prosecutor fee.
So, Ms. Bodette, state law allows in certain circumstances, law enforcement and the prosecution recovers some of their costs. An OWI is one of those offenses. So there is a $100 restitution fee back to the prosecutor and a $200 fee back to the state police. There was a $250 bond that you posted, so we will apply that towards your fines and costs. I did forget to impose, so 6 months of probation is $180. So if you end up staying longer than the 6 months, you'll be required to pay the monthly probation fee. Because I have sentenced you to a time of incarceration, even though it's time served, you do have the right to appeal that decision if you decided that you wanted to and could not afford an attorney to assist you. You have 14 days to request the appointment of an attorney. And just a reminder that any fines and costs that remain unpaid for more than 56 days will have a 20% penalty assessed to that. Do you have any questions for me about your sentence?
No, I do not.
All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make payment if you're able to. If not, get set up on a payment plan, and then go downstairs to district court probation and get signed up for probation.
Oh, thank you.
All right. Good luck to you.
Thank you very much. Your
Thank
Honor.
you.
All right, let's talk about that. This Wexford County docket rolled through a handful of cases, one dealing with a high-stakes bond issue, another teeing up a plea, and finally an OWI sentencing where the judge managed to sneak in a Bartles and James reference was Mr. Mansfield, whose bond sat at $100,000 cash surety after being charged with CSC and distributing sexually explicit material involving a minor. His lawyer argued that bond should be reduced because Mansfield was no longer on parole, despite what state records still showed. The defense painted him as stable, employed, and rooted in the community, stressing that he hadn't run during the long investigation. The prosecution countered with text messages corroborating the victim's story, a high probability of conviction, and the seriousness of the charges. After weighing it all, the judge left bond where it was, noting the severity of the allegations and the risk factors still on the table. Then came Stephen Crane, whose probable cause conference turned into a scheduling discussion. His case was headed toward a resolution that would reduce the charge to a high court misdemeanor, but the judge wanted the paperwork squared away. Rather than rush it, they set the plea for the next morning's docket, showing the system's preference for precision over speed when someone's record is on the line. Finally, the spotlight shifted to Miss Bodette, facing sentencing for an OWI with a blood alcohol level of 0.183. Her lawyer emphasized her honesty, ongoing counseling, and the personal stressors, divorce and job loss, that contributed to her lapse. The prosecutor pushed for supervision, citing the high BAC. Bodette herself promised the court she had learned her lesson and would never be back. The judge engaged directly, asking what she had learned, then reviewing her assessment. He chuckled at her, admitting her first drinks were Bartles and James wine coolers, but didn't let the levity overshadow the gravity. The sentence, 12 months of probation, eligible for early release after 6 months if compliant, 3 days in jail, credited as time served, fines and costs, counseling, alcohol safety classes, a victim impact panel, and strict no alcohol, no bars conditions. The courtroom atmosphere across these cases balanced weight and wit. The judge was stern on bond, methodical on procedure, and supportive yet cautious at sentencing, mixing accountability with opportunities for defendants to prove they can do better. Time to break this one down. Mansfield stayed locked with a stiff bond. Crane got a day to finalize a plea, and Bodette walked out with probation, fines, and a strong nudge to keep up counseling. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,